I should apologize. You might have seen on the paper version of the program that there would be an introductory speech by the European Commission Vice President Jourova. She was urgently called to Davos, so she's not with us, but please stay with us. We have a great panel. Let's start also by thanking our organizers, the CPDP, for putting up this great conference every year. I think we should start, because it's also post-lunch, with a dynamic round of applause for the CPDP team and our panel. First, a warning. This is a PowerPoint-free session, so precisely because it's post-lunch, we expect more dynamic exchanges. I know that the mic standing there in the middle of the alley is not the best option, but please, any time you wish to intervene, feel free to do so, and our experts will be there to respond to you. Let me start by presenting our panel and our speakers. To my left, first, Frederik Borgesius is professor of ICT at the University of Nijmegen. Sorry, he tried to coach me on this, and I'm very sorry I can't say it right. Apologies. Also, you have the full details of their CV on the website, so I will not go into that detail, just giving you their main affiliation. Seda Gürses is associate professor in the Department of Multi-Actor Systems at University of Technology of Delft, but you're also with K11. Benoit Frénay is the professor at the University of Namur in charge of data science program. And finally, Alessandro Mantelero, further to my left, associate professor of private law and data ethics and protection at the Politecnico University of Torino in Italy. So thank you all for being here today. I am Sophie Kwasny. I work for the Council of Europe in Strasbourg in France. And you're here to listen about AI and human rights. What is the Council of Europe doing for you? A first word of introduction about the Council of Europe, for those of you who do not know it. It's an international organization that celebrated last year its 70th anniversary, 7-0. I apologize for those who were this morning in another panel on digital identity in Africa, and I made the same introduction, but there's never enough pedagogy on the differentiation that needs to be done between the EU and the Council of Europe. The Council of Europe is promoting human rights, democracy, and the rule of law, has been doing so for 70 years, and notably our crown is the European Court of Human Rights, but we also have a global reach in our work because some of our conventions, like our Data Protection Convention, Convention 108, is also open to accession by any country in the world. Currently, we have 55 countries that are parties to Convention 108, so indeed a much further reach of our work. I would also mention our Cybercrime Convention that some of you may know, which also has a significant number of non-European countries joining. The Council of Europe for this is a unique forum to discuss the development and application of AI with regards to its impact on individual rights and the functioning of democracy. We have been doing so already for a number of years and continue. There's abundant work of the Council of Europe on AI. I will not list everything. There is work of the Parliamentary Assembly I will not mention, or in the criminal law sector, currently colleagues are working on substantive criminal law challenges posed by advances in robotics, AI, and smart autonomous machinery, including self-driving cars. But what I want to really highlight now are the instruments that have already been adopted by the Council of Europe. Some of them are soft law instruments. For instance, and Seda is representing the committee that led to that work, our Committee of Ministers, so the representatives of the 47 Ministry of Foreign Affairs of our member states, adopted a year ago a declaration on the manipulative capabilities of algorithmic processes Also, our Commissioner for Human Rights issued a paper unboxing artificial intelligence, 10 steps to protect human rights. We have a body specialized on the efficiency of justice, which is called the CPDP, that published a European ethical charter on the use of AI in judicial systems. So the whole question of predictive justice, even if it's willingly avoided from the title for good reasons. And the work I carry in Strasbourg on the Data Protection Convention and the committee of this Data Protection Convention adopted guidelines on AI and data protection already a year ago, I think, and Alessandro will be mentioning that. There are studies concerning the impact of AI on human rights that have been adopted on electoral processes and discrimination, and Frederik will be there to speak about this last point. But also, let me now mention the current work of the organization, which I consider to be very significant. The Council of Europe decided to set up a committee, ad hoc committee on artificial intelligence. So it's an intergovernmental committee representing all those states I've mentioned plus many others, also multi-stakeholder involving civil society representatives and private sector, to work on the question of the feasibility of a legally not legally binding, I shouldn't say legally binding, of a legal instrument on AI, because we have seen a complete multiplicity and explosion of various frameworks, ethical frameworks, guidelines on AI, but there is no legally binding instrument like we have, for instance, in the field of data protection. So the question is for that new committee, we love acronyms, so it's called the CARAI, that already met end of November for the first time. This committee is entrusted with the task of first mapping what the legal instruments are in the field, if there are gaps, and if there are gaps in terms of legally binding instrument, what could the Council of Europe do for that? So this is the work that is currently being done in Strasbourg. The next plenary session of this ad hoc committee is scheduled for March. It's a very important task. It had attracted a lot of attention, and so we shall see what the results of this work are. So this was the part of my introduction of the work, and now I will move to our panelists. Already I highlight the fact that each of you, each four are coming from the academic sector. You are all here in your capacity as experts involved either in the past or presently in some work of the Council of Europe on artificial intelligence. And so this is only to highlight that the Council of Europe, in its development of standards, in its preparation of studies and reports, is heavily relying on the experts and on our academic experts. So thank you very much for that. I will start with you, Seda, please. You have been a member of the Committee of Experts on Human Rights Dimensions of Automated Data Processing and Different Forms of Artificial Intelligence. Apologies for the length of the title of that committee. Because we love acronyms, it has an acronym. It's the MSI-OAT. The MSI-OAT already produced this declaration on the manipulative capabilities of algorithmic processes I mentioned. Also, a study on the implications of advanced digital technologies for the concept of responsibility within a human rights framework. And as finalized a draft recommendation, which is not yet adopted because this committee of experts has given its work to the next level, which was another committee, the Committee on Media and Information Society, that also finalized last year, and now submitted it for formal adoption to the Committee of Ministers, but it's not yet happened. And so this final piece of the MSI-OAT you were involved in is the draft recommendation on the human rights impact of algorithmic systems. So I'd be happy if you tell us more of your role and contribution to this work and how you can be proud of it. Thank you.
Thank you. Thanks so much, Sophie. Thank you, everyone, for coming here after lunch. I hope we don't have all the lunch dip together, but in turns. Charlotte called me, I think about almost 2 years ago now, to join this committee of MSI-OAT, as now I know how to pronounce as well, to look at the human rights implications of algorithmic decision-making systems. I was very honored that they asked me to join this expert committee, although I had never done something like this as a computer scientist, and I have to admit I was a little reluctant in human rights framework being the appropriate one to address the concerns around AI. But I have to say I had been somewhat converted, and the process of drafting this documentation was both a wonderful experience. Alessandro was there as well. I have learned a lot from my colleagues, and I actually have to say I like the document, which I can't say about all of my academic papers, so collective work can have sometimes a brighter side. I just want to talk a little bit about the strategy we took in addressing the question, what in the world are we talking about when we talk about AI? We went through a lot of the kind of laundry list of terms. We have algorithms, data, and then associated with concerns, we have fairness, accountability, and transparency. And coming from a background in computer science, all of these things mean something specific. However, they didn't seem appropriate to or lend themselves to a human rights analysis. And let me tell you why I thought that. Computer science as a field is known for its ability in the art of abstraction. So what we're very good at doing is saying, here's the scope of my model or my analysis, and we abstract away complexity, and oftentimes with that reality, to then build bare-bone models that we can manipulate efficiently and show characteristics of universally. It turns out when you want to be contextual and thinking about social justice in very specific situations, that kind of approach is not going to lead you very far. So we wondered how we could approach this, and the way we did it was to move away from algorithms, data, or fairness, et cetera, as the starting point, but to look at the production of actual software systems in the world as a way to bring in production, not just a consumption or abstract concepts like algorithms, but the production of software and the political economy that goes with them as kind of part and parcel of a necessary human rights analysis. So let me just try to explain what we meant by that. Very, very practically, it meant instead of talking about algorithms should do this and algorithms should do that, we assumed that algorithms are integrated in systems which have a political economy, which means that there are processes in which they have to be discussed with respect to their introduction. Should we introduce the system? Their design, how should the system be designed? Deployment, maintenance, and removal, because sometimes we will remove AI systems, and this is like removing part of your infrastructure, especially when the updates don't come in anymore. So we tried to make sure that the document approached all of these different phases in which systems come to bear algorithms and data into our lives. The other abstraction that we use is to look at the concept of optimization systems. By that, we kind of suggested that we do not look at information and communication technologies anymore. Instead, we're looking at systems that are, on the one hand, capturing behavior for the extraction of value through service architecture. So let me just explain the difference between the two. Whereas, let's say in the 90s, if you wanted to have software, you would actually get it from a box and install it on your device, and you would have no further relationship with the software company. With services, with service architectures, you have to connect to the servers of that company, which has still access to the code and continue developing it. And every movement, every kind of click, and any sort of interaction you have with the system is visible to the service provider, and they can use this feedback to redesign the system to make sure you provide the kind of behavior that is necessary for the extraction of value. So services not only provide value to us, but they provide value to the companies and institutions introducing them by the ability to, as a population, manipulate our behavior in a way that will allow them to make more value. That value could be political, but oftentimes it's economical. Another thing that has happened in the software industries with the introduction of service architectures or services is the ability to modularize or break down services and integrate them from other parties. So software companies no longer have to develop software from the ground up. They can just integrate third parties. So what software industries start doing is becoming a shell that orchestrates a bunch of service providers. So if you can think of a website, the authentication might be coming from Facebook, the payment may be coming from PayPal, the images might be coming from, or the videos might be coming from YouTube, et cetera. I'm not trying to promote these companies. But the point is that a certain kind of business agility has been made available through service architectures. And the business logic that is in these services is that you can externalize costs and risks to third parties. So as a service provider who introduces a third party, what I'm doing is I'm externalizing any risks and costs that I have to that party For example, if I'm doing analytics, I'm using the statistician of the party who's giving me the analytics service instead of having an in-house analytics person. And by virtue of using a third party, I can always go to a less costly service provider. I can move around very quickly. This creates a supply chain for software, which you will talk about too, Benoit, later on, which means that there's no single service provider that we're working with when we look at software production, but a whole supply chain where it becomes very difficult to also assign responsibility to exactly the parties that are providing potentially human rights violations. So by putting the software production into the document, we were able to address, as I said, these different phases, but also this kind of supply chain effect, which makes it very difficult to address responsibility. To give you an example of how optimization systems work, I would like to propose the example of Uber. Uber is, in a sense, using optimization techniques to match riders to drivers, but at the same time, it's optimizing by externalizing the cost of driving and riding a car all to the drivers, right? So Uber does not carry the cost of the cars and the wear and the tear and wear that the cars drivers accrue. Sometimes drivers will take out loans to buy the cars, and they will also wait around for customers. So all of those risks get externalized to the drivers, and part of the optimization is being able to provide services where you externalize these costs. So what we've tried to do is to think about the kind of social stratification and ordering and the inequities that get introduced through optimization systems, both in their production as well as in their deployment, and to think about how we can address that through a human rights lens. I'll stop there. Thanks.
Thank you, Seda. Let me move now to you, Alessandro, also because you made the link with this work at the time to ensure that we don't work in silos at the Council of Europe. That is, that this work that was done under the Media Specialist and Information Society Committee would also communicate with what was done by the Data Protection Committee. But so you precisely accompanied the Committee of Convention 108 on the elaboration of guidelines on AI and data protection. So what is, for you, the added value of that text?
Yeah, thank you. Thank you for the question. And I think that in the case of data protection, we have the benefit to have a binding instrument, that is the Convention 108, and in the modernized version, the 108 Plus. And this is important also in the future discussion about artificial intelligence and all this innovation, because this is a framework, and is an international framework. And so the work that we carry out in drafting these guidelines on artificial intelligence was basically to try to contextualize the principle that exists in Convention 108 Plus in the context of artificial intelligence. Because as you know, the convention, although it was recently modernized, has its roots in the previous convention that was adopted in the 80s. So this is more or less the work that also the CAI is carrying out. So to use the existing principle and contextualize this principle in order to address new challenges of a changing society, and more specifically focus on artificial intelligence. So in this sense, the idea that we had in mind, the key elements was, of course, the human rights focused approach, because this is the core value of the Council of Europe. And the idea was also to create something that was practical. Because we have a lot of guidelines on artificial intelligence, we have a lot of studies, reports that are very theoretical and address the things, provide a very general guidance, be transparent, artificial intelligence for good. So very general definition. And the idea was to provide specific baseline measurements, guidelines to three kinds of actors: the artificial intelligence developers, the manufacturers, and the service provider. So a document in which, if you are one of these, can find something that you can practically implement in your daily work in artificial intelligence. So this was the approach, and the approach was, of course, based on the idea that we have values, and our values are human rights. And so the idea that we have to embed these human rights in the device, in the product that you create in the field of artificial intelligence. And so what is also called a human rights by design approach, if you want. And to give you an idea of this very practical approach, for instance, the contextualization of the existing principle in Convention 108 in 3 main areas: data quality, risk management, and freedom. With regard to data quality, we focus on bias and on the risk that bias may create in a human rights context. And bias in terms of quality of data, in terms of bias of algorithm, in terms of decontextualization of the algorithm. There is a specific provision about the decontextualization that is a topic not a lot discussed, but in many cases we reuse model or we use data without taking into account the context in which the data were created or collected, and so on. There is some provision about data minimization. Data minimization, as you know, is a general principle in data protection, but should be better contextualized in artificial intelligence when you use usually a large amount of data. And so, for instance, we mention also some very technical aspects like the use of synthetic data or something like that. The second point on risk management, we follow the approach that we already point out in previous guidelines on big data. So the idea that risk management is a core element, and is also a core element in the modernized version of the convention. And in this sense, the risk management is based not only on the traditional risk management tools, but also on the idea to have a participatory approach. It means that the risk management is not something that is done by the company or by the government, but should engage also the potential arena, the potential context of people that can be affected, positive or negatively affected by the use of the instrument. And moreover, we focus on the public sector, because in public sector, of course, the use of artificial intelligence can be better regulated if you want, due to the fact that there are some specific commitments in terms of transparency, of equal treatment, and so on. And the public sector, moreover, can provide a useful contribution to a human rights-oriented artificial intelligence development through the public procurement regulation. And in this sector, we also focus on the idea of algorithmic vigilance. Algorithmic vigilance, it means that we have to find some solution to monitor the algorithm when they are used, not only where they are created, but what happens when they are used on a large scale for a certain kind of time. Last point, the freedom. And with regard to the freedom, we focus not only on the traditional idea of the freedom in terms of freedom with respect to the automatic decision making, but also the freedom of the decision maker. It means that the decision maker should be put in a position to take a decision. In many cases, the human in the loop has not a real power to take a decision. And the other point, from a general perspective, the freedom of individuals, the freedom of society or groups to decide if they want or not some artificial intelligence-based solution. And this is another important point. So I try to summarize our document in a few minutes.
Thank you. And actually, that's what the paper version of the document looks like. You can find it on our website, like the other reports and studies that we'll be mentioning. And if you have any question how to really find them, come and see me. Thank you, Alessandro. So now I'll move to Benoit. Benoit, you're currently working with us, with the Committee of Convention 108, on reviewing a recommendation that was adopted in 2010 by the Committee of Ministers, which was actually quite an influential recommendation, our recommendation on profiling. So why do we have to review this recommendation?
Thank you. Well, first I should say that it has been very enlightening and interesting to work on that recommendation as a computer scientist. So there are many reasons actually to change it. So it's actually quite old. Well, for computer science, 10 years is very old. So many new methods have arisen. For example, IA was not so much used 10 years ago. It's quite old, IA, but it has exploded since, for example, 2012 with the rise of deep learning, big data, and other methods. Second, of course, and as Alessandro pointed out, the use of these new methods comes with risk, many risks. For example, risk of robustness. We have to care about the quality of data. They are sensitive to the quality of data, sensitive also to attacks. There's also the risk of reliability. It's hard to enforce constraints on those systems and to verify that they comply with those constraints. It can be fairness constraints, but also the domain constraints, very technical constraints from the client. And it's also difficult to ensure transparency. It's hard to understand how they work, how they make decisions. Third, it's also important to understand that the development of those IA, and Seda already mentioned that, is complex. IA are pieces of software. They are small pieces of softwares in much larger softwares. They are not autonomous, and usually in a system we have several artificial intelligences working together. And they require the interplay of different actors with different roles. Third parties, open source communities, software engineers, and so on. I will take a small example. Let's say that you have a client who wants to design a new IA to solve a task. He will gather data, then go to a consulting company. We will use algorithms developed by third parties, usually open source communities, which are very, very important in my field. Then he will give the model to the client, go back and forth. And in the case of deep learning, it's even worse, because the consulting company, we use pre-trained models trained by very large companies that Seda named before. And actually those large companies, in some cases, do not even own the data to train those models. So they rely on other parties that provide data. So we have many different actors with many different roles, and it's really important to take that into account. Also, we had many new regulations, obviously the GDPR convention, the new version of the Convention 108, many new reports on artificial intelligence, big data, and so on. And I think also the question of individual versus collective risk that has grown more and more important in the last few years.
Thank you very much. Frederik, I have the paper version of your study on discrimination, artificial intelligence, and algorithmic decision-making that you prepared for my colleagues of the anti-discrimination department. So how can I be discriminated against in this AI environment?
Thank you, Sophie. Yeah, there are various ways how AI systems can discriminate. For instance, that it turns out, often by accident, to harm people with a certain skin color, for instance. And worryingly, it is often organizations with the best intentions using an AI system to, or computer system to help with decision making. So, for instance, there was a medical school in the United Kingdom, and they got so many applications, they thought, let's build a computer system that helps us make a selection. And you can imagine if you get 1,000 letters, that a human looking at all those letters, after perhaps 50 letters, you can't really pay attention anymore. So it's well-meaning to try to get help from a computer. So then but if you use a computer for selection of who will be good students for your school, you need to train that computer some way. And the school trained the computer on the admission data of new students of the 10 years before. Ended up that the computer basically only chose white men. Not only, but disproportionate amount of white men. So fewer women students, regardless of grades, and fewer students with an immigrant background. So then the school realized that the 10 years before, probably subconsciously, there was racism and discrimination against women in the way humans admitted students to the school. And then in such a case, an AI system risks reproducing or inheriting such bias. There are other ways how it can go wrong, but this is one example. This is an example of one type of discrimination by AI systems or computer systems. And we all know that we don't want that to happen in our society. We don't want discrimination on the basis of skin color or gender, political preferences, etc. So we know we don't want it, but in the context of AI, enforcement of the rules is often hard because such discrimination can be hidden. For instance, if you're a woman with an immigrant background that applied to this medical school, you don't know, you may not know that the computer made the decision about you. You may not know that women in general had a harder time getting into that school. So hard to enforce the non-discrimination rules that we already agree on in our society. And non-discrimination laws and human rights treaties say you should not discriminate on the basis of gender, skin color, etc. But AI systems also introduce new types of discrimination that are also a problem, which are even harder. They require more debate from us because non-discrimination laws and non-discrimination treaties tend to protect us against discrimination on the basis of only certain grounds: skin color, gender, sexual preferences, things like that. But AI systems can also lead, for instance, to discrimination of poor people, while financial status is not a protected ground in most non-discrimination statutes. So that means all the problems are the same there in the, as in the category of non-discrimination that we already agree on as a society, that we don't want it, so hard to discover, etc. But there's an added complication, namely, in which situations, or always or never, do we accept in our society that systems or decision-making procedures have the effect that economic inequality is enlarged. You could also phrase it differently. To what extent, if at all, should we accept discrimination of the poor, for instance? And there are more examples of new types of discrimination where non-discrimination law doesn't dictate the proper answers yet and doesn't dictate the proper goals yet.
Thank you very much. So we've had the first round of description, explanations by our experts. I think it's time for you to step in and ask directly questions to our four specialists. As I said, you will have to stand up in the middle alley and take the cue for the microphone and ask your questions. So please, if any, please. So. Yes, we will be taking several questions, so anyone who wants to come after, sir, please do so.
Okay, my name is Johann Schaas. I'm from the Institute of Technology Assessment of the Austrian Academy of Sciences. And my question would be related, I acknowledge that it is very important to have algorithms not biased, to make algorithms better. But on the other hand, I think it's not sufficient. Maybe we should use, or could also use, as already raised at the last comment or last sentence, use algorithms or the results to detect, maybe not to detect, because we know that many of the discriminations below, but to provide evidence about discriminations which are taking place in our society, and to develop policies maybe independently of artificial intelligence regulation. Thank you.
Thank you very much. Would there be another question so that we take several questions before they respond, the panelists? Thank you.
Yeah, thank you very much for this interesting panel. My name is Maya Burk and I work at Maastricht University. And I would like to ask two questions. One question is more general to all of the panelists, and the second one is for Frederik. So the first question is about the relationship between fundamental rights instruments and ethics guidelines. We have seen that many traditionally fundamental rights organizations such as the Council of Europe have now started to adopt these soft law instruments instead of binding instruments. And research shows that soft law or ethical guidelines, for example, ethical guidelines of ACM, are not very effective in practice. It is very difficult to enforce them, or there are no enforcement mechanisms. So I'm wondering whether these instruments are really what we should be seeking, or whether they are not rather just the first step towards the development of a more binding legislation. And the second question is for Frederik, related to that. So it seems that the current legislation on non-discrimination is not appropriate. And I'm wondering, what do you think, how should this new legislation be designed on non-discrimination? Should there be new grounds or other issues? Thank you very much.
Thank you. Please.
Hi, my name is Matthias Spielkamp. I'm from Algorithm Watch, a watchdog organization in Berlin. And first of all, I would like to congratulate you on many of the opinions and papers that you published. And I would like to ask one specific question about the expert opinion that Seda, you worked on as well. I brought my computer because I need to cite it. It said, in some cases, the application of an algorithmic system may prompt a particular higher risk to human rights, for instance, because it is used by states for their public service or public policy delivery, and the individual does not have a possibility to opt out or suffers negative consequences as a result of the decision to opt out. States should establish appropriate levels of transparency about the public procurement, use, design, and basic processing criteria and methods of algorithmic systems implemented by and for them or by private sector actors. So we as an NGO have started asking for a public register of ADM systems being used in the public sector. We shy away from asking the same thing for the private sector right now for some definitorial problems, but I would like to ask, this has been debated a lot, and there was opinion published lately in the Netherlands of an, it was not a committee, but it was a study being done, and they recommended to not ask for this public register because they argued that it is really too hard to define what these ADM systems are and where they pose this higher risk. And I would just like to hear your opinion on whether and how we can overcome these problems.
Thank you. Thank you very much. I think we already have a lot to react to and respond to. I would just respond about the concerning the question on those soft law instruments that we're working on in the Council of Europe, to highlight that I think they are very important. There are a means for us to go further than the legally binding instruments we have. And if I take the profiling recommendation of 2010, it was brought in the modernization of the convention. So it was this inspirational text, non-binding at the time. But then when we modernized the convention, the risk approach and some of the notions we had in the profiling recommendation on the necessity to bring the human back in this automated chain, then translated into a binding instrument. I think that was very important. And you can also see the other way around. You can see the European Court of Human Rights in some of the decisions quoting some recommendations which are non-legally binding, but because they go into a very particular and precise topic, it gives flesh to those core human rights that we are protecting. So I think it's very important. So I don't know how you want to respond. There were direct questions for two of you at least, Frederik and Seda, but I think Alessandro also could react to some. Please go ahead.
The last one. Oh boy. Okay. Oh, I was preparing for something. Can you start? Yeah. Thanks. Yeah.
Okay. No, I only comment about my question because you mentioned soft law and you mentioned ethics. I think that we have to clarify the distinction between soft law legal instrument and ethical guidance. Ethics and law are two different realms. Of course, are complementary. Of course, are theoretically, historically correlated. But in this debate on artificial intelligence, there is in Europe a sort of polarization, if you want. there is one initial approach adopted focused on ethics for artificial intelligence, and another one focused more on human rights. European Union started with ethics, Council of Europe started with human rights. And I think this is a different kind of approach in terms of focus, and so also in terms of soft law, I think that one thing is having a soft law but grounded on a convention, grounded on some binding instruments, and so the soft law is a sort of application, contextualization, tailored application of the principle of the convention. And another thing is adopting ethical charters based on ethical frameworks. And in some cases, ethical frameworks that are not defined, because we have to take into account that there are very different kinds of ethics. And many times we talk about ethics without focusing on and discussing which kind of ethics. If is the ethics, European ethics, the Asian ethics, and inside the European ethics, which kind of ethics? Because there are very different kinds of ethical approach. So I want to underline the distinction between soft law and ethical charters. I think that is important. And the last point, and then is public register for artificial intelligence. Who knows the history of data protection knows that at the beginning, we start with the license system. So with a system that required the registration of the database. And then we abandoned this system because it was cheaper to have the hardware, and so it was easy to create a database without being known. At the beginning, for instance, in India, there were only 2 big mainframes, and so it was quite easy to find where they were. But when we moved from big mainframe to personal computer, it was more difficult. And I think that for artificial intelligence, we have the same challenge. It's not so easy to monitor the consistency of the list and what happens in the practice in the office of the public administration sector. Thank you.
Hi again, everybody. Thank you for all your inspiring questions about... yeah, I agree. In data protection law, we tried to have a register of all databases, and we gave up because there were too many. Then again, I could imagine that for the shorter term, we still aim for a register of automated decision-making systems owned and used by the public sector, because there's a big lack of knowledge about what exactly does, for instance, I'm from the Netherlands, in what situations and how often do computers now make decisions about people with heavy effects. So as a short-term measure, I think it's worth exploring, although like Mr. Spielkamp says, it is hard to define an ADI system. And then Marja Brukkan asked me about how should non-discrimination law be amended. First, I want to emphasize that I didn't want to make the point that non-discrimination law is bad or completely broken or something. In the short term, enforcement of data protection law and non-discrimination law, good enforcement with technical knowledge at non-discrimination bodies and data protection authorities, for the short term that is the best strategy and can get us very far already, because many, perhaps most types of unfair discrimination by AI systems are already a type of prohibited indirect discrimination. So we should start with enforcing the laws that we have already. But the more exciting question is, of course, how do we make the laws even better? I think that the most fruitful way forward, perhaps the only fruitful way forward, is regulate sector by sector. Because 100, 200 years ago, we couldn't adopt one statute to regulate the Industrial Revolution. No, we needed consumer protection law, safety laws in factories, laws how you build houses in crowded cities and so, etc. So we need an enormous body of laws, and some of them were more successful than others. We were not that successful in environmental protection law, for instance, but enormous bodies of laws. And I think the same is here too. For instance, one thing that can go wrong with AI systems is predictions that are wrong for an individual, because an AI system is often makes decisions that go roughly like this. If a person has characteristics A, B, C, there's an 80% chance that the person has characteristic D, for instance, will be slow paying back a loan, or 80% chance, higher chance than others that he or she commits fraud, etc. Or has a higher chance than random people to click on a certain advertisement online, because that is one of the big money-making machines for Google and Facebook, is targeted advertising. But these wrong predictions are completely different. Google keeps on showing me shampoo ads, like hair products. So that is a wrong prediction, that I will click on those ads, but not really a problem. But if the customs or the police wrongly predicts for the same people all the time that they are probably a criminal, and always takes the same people out of the line at airports, etc., that is a much bigger problem. So you see that from a technical perspective, namely sometimes wrong predictions, it is the same in different sectors, that the results are completely different. And therefore, with that, I want to illustrate that I think new rules should always be sector specific. Like AI in the insurance sector has different risks than AI in online advertising, and has different risks than AI in predictive policing, etc.
So I think I'll try to be relational. So I'll also respond a little bit to the discrimination question. As somebody who's done anti-racist work in Europe, I have to say that most non-discrimination law has been not sufficient to address the needs of communities in Europe. And also there's a kind of normalized social stratification in Europe, especially when it comes to people with immigration background, and also if they are Muslim. So I think we have completely normalized social stratification in terrorism laws and migration laws. And I think we should distinguish between, on the one hand, the use of technologies to enforce such stratification, as in the use of content moderation, or the new laws, the anti-terrorism laws that are going to affect content moderation, versus, let's say, human resources application that will be used, which might introduce or amplify existing, but also introduce new ways or new forms of discrimination and social stratification or ordering. And I'm not sure, especially for those that are kind of normalized in Europe, like this idea that immigrants can have less rights, or their rights can be removed very easily. It's not just an algorithmic problem that we're looking at, and the non-discrimination law has very little to say about it. I think similarly, when we look at, for example, the financial system has moved from giving certain people loans to not giving certain people loans, to a risk-based model. When you're high risk, you pay more money. And what that means is that if you're poor, you pay more money to take out a loan. This is obviously a very unfair system, and I don't think it's going to be very easy to get non-discrimination law to get the financial actors to budge in their profit schemes. I'd be very happy to see that law happen, but I think we're a little far away from it. At the same time, so I'm going to somehow combine the question from Matthias and the gentleman who was asking about maybe we should study how discrimination or social stratification happens. I think it was you, which is that currently computer scientists look at the inputs and outputs of algorithms to determine, there are a few exceptional papers, but you look at the inputs and outputs to see if there's unfairness or kind of unfair outcomes as a result of the algorithm. However, we have very little studies that say, let's look at the context. Let's look at the sector that is impacted, or the group of people who are impacted, and then start with their complaints and walk ourselves back into the algorithmic system. And I think we need to do both, right? I don't think it's sufficient to remain in the analysis of algorithms and say, oh, we have some sort of parity measure. We used to find out that our algorithm would send would over-police certain neighborhoods, and now we make sure we over-police all the neighborhoods. That's still a police state. So we need to kind of find ways to start from the context and then go from there to what systems are causing problems, instead of starting from algorithms and assuming that eventually we'll find the people, because what we're probably going to find is system outputs, and that's not going to lead us to the people. So how that relates to the question from Matthias is that I think the question for you is, what is the purpose of this register? If the register is going to help in understanding the risks and harms caused by systems and to kind of be able to follow them back to the systems that produce them, I think this is very useful. If we think having a list of systems, even if, I don't know if it's algorithms or companies or you know, a kind of list that shows for which purposes what systems are being put into place, we might get stuck in a technocratic loop where we're constantly looking more and more at systems instead of their impact on the world. And I think this is one of the biggest dangers with almost all of the propositions coming out of law and computer science, which says, let's look at the specification, let's look at the inputs and outputs, and if we can prove some properties about that or make those properties transparent, we're done, which does not tell us what these systems are doing in the world. And as I said, they're creating stratification in unexpected ways. Uber is causing a lot of dispossession among poor people who are investing their time and lives into these cars and driving. It turns out they're predominantly immigrants, and so they're not even going down the litigation way because they already have few rights. So if we don't understand these systems in the world, it's going to be very difficult to start with computer science and end with computer science and, you know, smear it with a bit of law and expect some results. And finally, for the ACM ethics guidelines and ethics guidelines, who should they be applying to? I've been studying developers with respect to privacy engineering. So do they have, so to say, the capacity or the possibility to apply good privacy decisions in design? However, what I've been finding out is, aside from the fact that oftentimes they don't know what to do, we don't give them enough resources, they're in part of this production infrastructure that I introduced at the very beginning, which basically encourages them to do data-centric development, which encourages them to use third parties that might be doing things that violate privacy, but that are very difficult to test because they're hidden behind APIs. And they are definitely encouraged to optimize both the costs on their end and optimize and use a utilitarian logic in applying services. So if we want these developers to develop more fair and just systems, we need to have tools that change the organizations that employ them to make sure that these are not the only ways in which they develop software. We cannot expect individual developers or developer teams to make a difference. This is not to say they cannot subvert, but that's what they're doing. And I don't think ethics guidelines in that sense are sufficient. They're helpful, but they're not sufficient.
Yes. Shall we see if we have more questions from the room? Yes. Gloria, I think. You're too far from the mic. Gloria.
I'm Gloria González-Fuster from VUB. I have a question. It's maybe not directly to you, but I see this ad hoc committee on artificial intelligence has, as part of its mandate, to take into account the gender perspective. It's a beautiful sentence. It says, take into account the gender perspective and the rights of people with disabilities. Okay, I don't know what it means, but my question is, what do you think about how the future of the work of the Council of Europe and artificial intelligence will take into account the gender perspective? You mentioned gender, Frederik, and for me it's really an interesting thing because you mentioned that it's taken into account by discrimination law. But normally the link between discrimination law and data protection are the special categories of data, so you cannot, the grounds on which you cannot discriminate are all reproduce special categories of data except gender. Gender is not a special category of data. And we know that all these algorithms massively, accidentally discriminate on the basis of gender. So what could be the future in this area? Thank you.
Thank you, Gloria. Any other question for our panelists? No, this one will clearly be for you, I think, Frederik. But just to highlight that this need for a gender perspective in the work is quite standard, actually, for any committee work. So it's there, but I think it's indeed very relevant. And Frederik, you have the floor.
I'm going to think out loud a bit in reaction to this question and perhaps not really answer it. So, Professor Fuster-Gonzalez just reminded us that in data protection law, we have these categories of sensitive data, skin color, sexual preferences, etc. And these, almost all of these categories are categories of data that people have been discriminated on. On the basis of these types of data, people have been the victim of discrimination. Similar was what I mentioned earlier in non-discrimination law. You have what they call protected grounds in non-discrimination law, like do not discriminate on the basis of, for instance, skin color. And indirect discrimination says do not do any activities that happen to harm people with a certain skin color, regardless of what the goal of the organization was. And Gloria pointed out that non-discrimination law says you cannot discriminate on the basis of gender, but gender is not a category of sensitive data in data protection law. Can we just add it? Probably not, because to the list of sensitive data, because the rules are so extremely strict for, at least on paper, for sensitive data in data protection law, that that wouldn't work, probably, in practice. But the deeper question was how to take gender better into account in these types of discrimination discussions. I don't directly know, but what is also important, there are many reasons to aim for variation in one's workforce. And for some of the mistakes that we've seen in AI systems, for instance, facial recognition systems that don't recognize faces with a certain skin color, for instance, perhaps Silicon Valley companies would have thought to check for that problem if they had more people with varying skin colors among their workers. So, and there's also in many AI companies, Silicon Valley companies, there's more males than females, which may result in fewer females warning, like, hey, did we think of this possible problem? So part of the policy solution is pushing even harder for a varied workforce, I think. You, anything to add?
No, I want only to mention that the recent created group, ad hoc committee on artificial intelligence of the Council of Europe that work on this future regulation has specifically appointed a gender equality rapporteur that will focus the entire work, not only in order to focus on the gender debate inside the future regulation, but also the gender debate inside the discussion of the future regulation. So it's not only on the target, but also on the methodology. So this is to point out that the gender issues is specifically addressed in the procedural approach adopted by the ad hoc committee on artificial intelligence.
Thank you. Yes, please. If you introduce yourself. Thank you.
Hello, I'm coming from Japan. I'm Shibuya University Associate Professor. I'm Akemi Yokota. I'm a member of the subcommittee to risk assessment for the AI program in Japan. But I have a question to how to develop the legal system sector by sector. I totally agree with Frederik's opinion to we have to consider regulation by sector, health problem or something like transportation problem. But AI guideline also we have, but the regulation itself is very specialized sector to sector. What should we do with connected with very various general principle into the several areas to several regulation? If you do have an image for the procedure or something developed to management or something like that, anyone, okay, please express your image to how to introduce guideline into the several sector.
Thank you. Thank you. It's actually a question we were having with Frederik, because this ad hoc committee on artificial intelligence that has been set up with this mandate now to map the standards and fill the gaps has a general mandate of a legal instrument on AI. And so Frederik pointed out the fact that AI in healthcare, AI in manufacturing, whatever, are all very different. So could we, Council of Europe, under this framework, have something that is meaningful? And it's a question I wanted to put to you. Is there merit in developing those, this general legal framework, which I think there is?
Thank you for your question. So we have in law, you have on top, you could say on top, the most abstract goals that we have are human dignity, and then just below that you have human rights. We all agree on them. Privacy is important, freedom of expression is important, perhaps ethical principles are a bit up there, even vaguer. AI should work for the common good, etc. We all agree with it, but it doesn't help you so much further in practice. And then when you go down, you can make the human rights a bit more tangible in the AI system, but still horizontal. And they're probably useful, perhaps even necessary, but not enough, because then you get stuff like, in cases where it counts, ensure that decisions are explainable or something. Useful, but still vague. And then when you go down and down and down, what could you do sector by sector? I'll give one other example. So earlier I said incorrect predictions or false positives have completely different effects in different sectors. And I'll give one more example, not of a false positive, but one sector where a certain problem is important that isn't relevant in other sectors. Like AI systems make it possible for insurance companies to predict better and better and better who will have, for instance, car accidents. So you could, for the most risky people, now already you could say men under 25, they are risky drivers because they can behave like teenagers, basically drink and drive, etc. But you cannot make that much more granular and detailed, like people who drive mostly at night or who drive in Brussels during traffic hours, except people that have SUVs, but then with an exception for pink SUVs and another like super complicated stuff that predicts better and better who will have accidents. At some point, the monthly premium for the most risky drivers becomes so high that they're basically uninsurable. I don't know yet what the best legal answer should be here, because you could also think some risky drivers, when they drive at night, may be risky drivers because they have to work 2 jobs and they're super tired. So perhaps they can't really help being risky drivers because they just have to work too hard, etc. I don't have an answer here, but it shows that this segmentation in the insurance sector requires us to grapple with questions that are different questions than in other sectors. Well, I could... one rule that you could consider is there's a maximum of 5 segments in how you do risk assessments in insurance. In a certain, probably even insurance, we still have to cut up in different sectors, because travel insurance you can just choose not to take. It's kind of a luxury thing. Some people say, well, in many societies and countries, you're required to have car insurance, so not being able to insure your car basically handicaps you. This long story was meant to illustrate that another sector that triggers different questions.
I have a slightly different opinion, you know. No, because in order to regulate artificial intelligence is a tricky problem. The risk is to repeat what already exists, and this is not a good solution. I'm much in favor of the approach adopted, for instance, by the European Union in the case of e-commerce. You know, e-commerce regulation focuses on the part that is not already covered by existing contract law, only for the new challenges related to the e-commerce. And I think that in artificial intelligence, we need a general principle, a general instrument, binding instrument from my perspective, a general binding instrument that covers all the sectors, providing the fundamental principle or the already existing fundamental principles but contextualized for artificial intelligence. And this is, for me, is the first layer. Then, of course, we need a second layer, and the second layer can benefit from the experience of the co-regulation that is well known in the sector of data protection, for instance. The second layer, it means that if you have some general principle on artificial intelligence, then that principle should be contextualized. Of course, in warfare, in healthcare, and in finance, we have different subsector principles and values that should be safeguarded. And in this sense, we can adopt a soft law instrument, I think, because to be clear, we cannot imagine to spend 5 or 6 years each time that we want to make a sector-specific regulation, because artificial intelligence goes fast. And so this is also a problem of legislative technique. I think that is important to use co-regulation. Co-regulation doesn't mean deregulation. Co-regulation means that there is a series of principles. The soft law should be compliant with these principles and only apply this principle in a more specific and tailored manner. And by the way, the experience of data protection in soft law and co-regulation is very positive, because in the countries in which were adopted co-regulatory instruments, they make possible to engage the stakeholders, including the data subjects or companies and so on. And so people that know what are the issues in many cases in a more clear manner than members of the parliament sometimes. So I think this is a different, partially different model, but I think it's a potential solution.
I think we agreed that I may have misemphasized my answer. I think horizontal rules can be useful and have to be supplemented with sector-specific rules. And also a good point, this becomes very legal now, but perhaps the more detailed the rules are, for more detailed rules, you tend to need to have possibilities for quicker adoption. So lawyers would say formal laws that have to go to 2 chambers of parliament, etc., may be too heavy an instrument for the most detailed rules, because you probably want to adapt them every 2 years or something. I think we largely agree.
Thank you. Do we have any? Yes, can you please stand up and come to the mic? And I think it might be our last question, or if there is another burning question, please stand up now. Yeah.
Thank you all. It was a very interesting conversation. I'm Zedu from Leuven University, and I would like to ask more information on the committee CPDP from Council of Europe. And I was wondering about procedural justice and AI, because I know CPDP is concerned about efficiency in judicial systems. Has ever the question of AI as a judge making decisions in courts come up on the conversation of CPDP committee? And if so, what was the conversation about? Yeah.
I will. Yes, the question was about AI, the use of AI in justice, and actually I mentioned it in the opening. There is a body in the Council of Europe which is called the CPDP, the European Commission for the Efficiency of Justice. That has nothing to do with the European Commission, but it's the European Commission for the Efficiency of Justice that has adopted a charter. It's called the European Ethical Charter on the Use of AI in Judicial Systems. It's a great document, you can find it online, and that provides already a very clear set of guidance on the topic and the use of AI in judicial systems. Please, Mark.
It's a very short question. Thanks, Sophie. Mark Cole, University of Luxembourg. Looking at the title of the panel, I would like to go to a more higher level and not the details of the individual reports. This morning in the Facebook panel, there was a discussion whether we should maybe aim for global standards in AI regulation or AI impulses. It's maybe a question that even goes a little bit to the moderator, but also the perspective of the experts. How strongly is the Council of Europe seeing the possibility, similar like with the original Convention 108, to become a leader if it's not the European Union, the Council of Europe, sending out signals to the world? Is it maybe too ambitious, or should that be something that really the Council of Europe should be saying, we are a potential forum, think of the Cybercrime Convention? And I know that's probably going to give you a headache, the question, but I wanted to use it because what's the Council of Europe doing for the world and not only for us?
Thank you. Thank you. I'm only serving as a secretariat, we're only serving the member states, the governments. So really it's for the governments to make that decision, to agree that there is a need for a global legally binding instrument. So the establishment of this committee, the CAI, is the first step. It's already the fact that those 47 member states have said, okay, enough ethical standards and guidelines, we want to work on a legal instrument. And so they've given the mandate to the committee, which I think is already a very strong signal, and it's 47 countries giving that signal. The fact that the first meeting of the CAI end of November was packed, the affluence was enormous. I see people in the room who were there, coming from other regions of the world too, is also an indication of the importance that governments are attaching to this work in Strasbourg, not only as being European, because precisely there were also non-European countries based on our cybercrime and data protection example. So I think that's really the potential of the work of that committee and why everyone should contribute. There's also an obligation of a broad consultation opened on the outcomes of the work of that committee to involve everyone, because I think it's a great opportunity if we think that we need to provide a legal, strong instrument in the field. So we are nearly at the end of the panel. A quick last word of conclusion from each of you, and then we'll start from Alessandro towards me.
A short comment related to Mark's question. In my experience as an expert of the Council, the Council is an interesting context because there is less pressure respect to other institutions that are territorial based. And this gives us the chance to have a forward-looking. And for instance, in the big data guidelines, we introduced in 2016 the idea of ethics. And at that time, the feedback was, why ethics? And now everyone like ethics, so I'm very positive. And I think that this is an important fora. And this is related to the Mark question. I think that the Council of Europe have more chance, compared to other international or multinational bodies, are more chance to adopt a forward-looking. And this kind of approach can benefit the member of the Council and the other countries. It doesn't mean that the Council of Europe will be able to have an official global standard. But of course, it's a good context to have a sort of laboratory for a future standard. And then this future standard can be implemented by the European Union or other countries. But I think the level of freedom and the level of forward-looking that we have in the Council of Europe is very positive. Thanks.
Thank you. Well, to conclude, first I would like to thank again the Council of Europe. And I think something which should be encouraged is what they are already doing, is to invite experts from many different fields, including computer science. Why? Well, because if you want law text to be enforceable so that they can be turned into real solutions, real-world solutions, you need to have laws who are in line with the technical productions. So we need to have the right words. So for example, if I go back to the recommendation in 2010, they were using the word profile, which was adequate at that time, but which is no longer adequate for IA. So we need to talk, lawyers, computer scientists, together. And I think we should really encourage this multidisciplinarity, support academic research also in computer science, because that's where the technical solutions will come from, support also, and take into account third parties, in particular open source communities, then they are very, very important. They are fundamental in artificial intelligence. We need to take them into account, their specificities, and also to allocate resources to digital literacy. Because if we want, for example, people to ask questions about the decision made by IA, well, we need them to understand what is an IA in the first place. They need to be able to understand what the expert is going to tell them. So we need to educate people.
Seda,
yeah, shortly. Yeah, I think it's really great to see all of these legal efforts. We have to. There's some part of me that is very confused because the software industry is very centralized and it's actually creating a sort of global dependency on a few players. And I would like us to see. To be cognizant of when we make laws, like let's say if we're asking for fairness to be applied, are we actually consolidating power in the hands of a few companies that can apply those laws? And how much are we empowering local computational infrastructures to be developed and local economies to be sustained instead of becoming dependent on these few companies? And I think the same for the sectoral question. Neural networks get applied in almost any sector. So there's this kind of feeling that there's these universal tools that can be applied elsewhere, everywhere. They're universal, and then there's this kind of knee-jerk reaction to say we should have global laws that deal with these global companies with universal technologies. No technology is universal, and I think we should be very cognizant of differences and local conditions and needs, and make sure that we don't go into the trap of globalization, pulling us into global structures that undermine the local structures that are important for democracy.
Thank you. Frederik, last
I'll
word.
just add thank you and enjoy the rest of the conference.
Yes, we're coming to the close, so don't forget to take your daily dose of Privacin and celebrate Data Protection Day on the 28th of January, which is the anniversary of Convention 108. And please join me in applauding our panelists. Thank you very much.